Welcome to Part 10 of Bright Ideas, a PTI Nebraska workshop on special education law. In this segment and the next, we're going to talk about how the law steps in to protect the rights of parents and those of the school when disagreements arise between you and your child's school district. Several times in earlier parts of this workshop, we've touched upon the term procedural safeguards. This is essentially a buzzword meaning protection. There are procedural safeguards written into the law which protect parents and children with disabilities from being mistreated or ignored by state and local education agencies. And there are procedural safeguards which protect the state and local schools from being badgered with unreasonable demands from parents. Instead of procedural safeguards, Nebraska's law refers to its protection mechanisms as dispute resolution, a term that's somewhat easier to grasp. From time to time, disputes are going to arise over the treatment or the placement of a child, and there are many ways to resolve them, both formally and informally. To ensure that parents know how to proceed in the event of a dispute with their school system, the law requires that a copy of the dispute resolution methods be furnished to parents each year. Parents will also receive this information upon the initial referral or request for an evaluation, the first occurrence of filing of a complaint, or upon request. The information will include a full explanation of the remedies available to the parents, written in their native tongue unless it's clearly not feasible to do so, and written in easy-to-understand language. Working in concert with your child's IEP team, you always have the opportunity to contribute your views to any changes the school may propose which alter your child's identification, evaluation, or placement, anything affecting the guarantee of a free, appropriate public education. And generally, you're likely to find yourself in agreement as part of a consensus. It may happen, though, that the school district might seem to be ignoring your input and speeding off in a direction that you disagree with. For your protection, whenever the school proposes or refuses to initiate such a change, they must furnish you with a notice in writing in your own native language, which includes a description of the proposed or refused action, an explanation of why the action is being proposed or refused, a description of alternative options considered by the IEP team and the reason why those were rejected, and a description of all the factors relevant to the school's proposal or refusal. The notice must also inform you of the course of action you may take to formally dispute the action, along with sources of assistance who can help you understand your rights, such as an organization like PTI Nebraska. The best way to resolve a dispute, of course, is the simplest and least costly to both parties. Just come to an agreement. The law gives both parents and school officials a lot of specific guidance, and all of it is centered on the child. Disputes often arise simply because one or both parties has allowed the child's needs to slip out of focus. If everyone on the team will commit to refocus on the child, disputes can disappear. One way to help achieve resolution is to request a facilitated IEP meeting. While this solution is not a part of federal law, it's available in most Nebraska communities and encouraged by Nebraska's Department of Education. A facilitated IEP may be requested by either party, and participation is voluntary for both. A trained facilitator is brought in at no cost to parents, usually from the local school district's administrative staff, but a qualified attorney may serve as a facilitator as well. The objective is simply to put the child's needs back in the center of the discussion and get both parties to agree on a solution for the child's benefit. If that doesn't work, Nebraska's Rule 51 lists several escalating steps in terms of both cost and disruption to the routine of all parties. At the conclusion of each step, it's hoped that an agreement will have been reached that both parties can embrace. If not, the next step in the dispute resolution process adds another level of appeal, but at the cost of ever greater disruption to routine and ever greater expense to both parties. Throughout this escalating process, the law sets out time limits for each party to respond to the other. The collective result of these time limits is that each escalation becomes further removed from the subject of the initial dispute by weeks or months, until, by the ultimate step of the process, years have gone by. And years in the life of a child with a disability are a precious commodity indeed. It's always to the child's advantage for disputes to be resolved quickly. The first step actually prescribed by law is formal mediation, used when the dispute centers around a difference of opinion between parents and the school system, involving identification, evaluation, or placement of the child, or the provision of a free, appropriate public education. Mediation may be initiated by either party, and again, participation is voluntary for both parties. In this case, an impartial, trained mediator presides over the meeting and tries to bring the parties to an agreement. There's no cost to either the local school or the parent at this step. The cost of the mediator is borne by the state education agency. In the event that the parents allege that the school district is actually in violation of either state or federal special education law, the parents must initiate a state complaint. This will be a written complaint sent to the Nebraska Department of Education Special Populations Compliance Officer. There's no cost involved in initiating a state complaint, but it does require specific documentation which supports the allegation that the school district is not complying with the law. After reviewing the documentation, the Department of Education will issue its findings of facts and conclusions in writing and either require the school district to comply or inform the parent that the school district was not found to be in violation of the law. When mediation fails to resolve a dispute, or one party wants to appeal the findings of a state complaint, either party may file a request for a due process hearing. As a parent of a child in the special education system, you may, from time to time, hear of due process in regard to the final arbitration of a dispute. And that's exactly what it is. It is a legal process to decide an issue, and it's the last step, short of a civil action in a court of law, toward trying to resolve a difference of opinion. It is not to be undertaken lightly. So after a request for a due process hearing has been filed, but before proceeding to a due process hearing, the local school district must make one more attempt to bring the parties together outside of the hearing room. Within 15 days of a request for a due process hearing, the school will convene a resolution session for that purpose. There, the school district will once again try to focus attention on the child and the child's needs, addressing the three specific key concerns of identification, placement, and provision of a free, appropriate public education. Here, too, there is no cost to the parent. The resolution session will either resolve the situation, fail to resolve the situation, or result in a draw in which the parties agree to disagree and both waive the expense and trouble of the due process hearing. The failure of the resolution session will allow the matter to proceed to a due process complaint hearing, presided over by a state-appointed hearing officer whose decision is final. As you can see, the process is heavily weighted toward resolving disputes quickly, cheaply, and with the least disruption to routine. But if you need it, the law ensures your right to press your argument before several levels of appeal. The procedural safeguards written into the federal law guarantee that, as parents, you have access to examine the education records in your child's file with only a few particular reservations. And you're guaranteed the right to participate in all meetings relating to your child's evaluation and placement, again with a few practical reservations. For example, the intent of the law is not to prevent your child's teachers and service providers from informally discussing your child's program among themselves, so such meetings are not prohibited. However, no one may make any modifications to your child's program without your having the opportunity to provide your opinion. It's important to note that throughout the course of any dispute, you should be maintaining records of your own as scrupulously as possible. Remember that school personnel are documenting everything on their behalf, so you should too. You should be writing down every occasion on which you speak with school personnel, summarizing what you've been told and by whom. You should be noting your observations of your child and his or her progress, or lack of it, and documenting any changes you see as they relate to your child's program and placement. These documents will put you on an even footing with school personnel and professionals at any level of dispute resolution later on. Bear in mind that informal resolution of disputes is better in the long run for everyone involved than the formal steps that we'll discuss in the next part of this workshop. This concludes Part 10 of Bright Ideas.